All right, everyone, I think we can probably get started. This is Barron Circuit Court. This is our civil docket. I normally just go through these in the order in which they are appearing on my docket. However, if someone is needed in another Zoom meeting or has another court waiting on them or whatever the case may be, I'll be happy to move you up the food chain there and get your case taken care of so you don't get a judge mad at you somewhere. All right.
I'm not hearing it.
The first thing I've got is going to be 19 CI 208. That's Estate of Johnson et al. Versus Estate of Gray et al. Several of you are on here for that case. That is a motion to modify, I believe, expert disclosure deadline based upon this case has been one that there's been all kinds of different regularly recurring complications due to the number of people and the fact that it's hard to get in touch with everybody and have people come into our offices and things of that nature. So I'm happy to hear. I mean, I think the motion is fairly self-explanatory. Mr. Portwood, I don't know if you need to add anything to that or not. If you don't, then I'll hear what anybody has to say if there's any opposition to it.
I would just say, Your Honor, that we are in the process of talking to the mediator, and he is very busy, I think, with some of the offices opening back up and just the restrictions loosening a little bit. He's been absolutely slammed. So it is taking him some time to get back to me. But I am in the process of getting dates, and I'm going to circulate those. I think that his office said that his first availability was going to be in June. And so that's the basis for our motion because, you know, we finally have, I think, everybody on board with the settlement and the mediation type approach to this. And I think that's, you know, probably beneficial for everyone due to the number of parties. So we would like an opportunity to do that before we incur the expert burden and the expense that goes along with that.
I understand. Is there anyone, I haven't received any pleadings in opposition to your motion, but that doesn't mean that there isn't an opposition to it. So if there is, somebody speak now. Okay. It would seem like to me that certainly makes sense. It doesn't sound like you have an exact date for your mediation yet, but it sounds like you're probably going to be able to get that done in the near future. Refresh my memory. I can't recall whether you said something specific in your motion about when you would propose to schedule that deadline. I would expect, the mediation, you would, having a little bit of experience with these things on the non-participatory end, I know that there are occasionally mediations that aren't successful at the time, but everybody kind of keeps talking, and sometimes they even have a certain amount of time built into them. You have 72 hours to respond to this or whatever. So I don't know what you have in mind. Throw that out there.
Right. So what we had proposed a long time ago, and I think it's still the direction that we should probably go, is everyone kind of submit to our mediator, and we all agreed to that mediator back in, I think, the first part of 2020, before COVID and all that. And everyone throw everything to him. He takes a look at everything and he says, this is what, we're kind of looking at for these claims. We think this one's worth maybe this much, and this one is this much, and that gets the ball rolling. And then everybody can, either agree with that assessment or object to it, but at least gets the discussion going. And then I think we can set a formal mediation date, because I think many of those parties either have or will be submitting those sort of, I guess you would call them almost like a demand package. But it's to the mediator, of course. And so that's the way that we had approached it in the beginning. And somehow it got off track, and We just want to get it back on track and then hopefully get everything resolved.
I understand. I mean, do you all think, all of you that are present on here, do you think that you can come up with some sort of agreement that if the mediation is unsuccessful, then within so many days after the mediation, that'll be when the disclosure deadline is? I mean, because since I don't know when the date is, it's going to be hard for me to pick a date. But I could easily say something like, 20 days after, or 30 days after, or 15 days after, or whatever. But it seems like maybe you all could talk about that among yourselves, since you're in the frame of mind to have a mediation anyway. You could probably work that out and submit an agreement on it.
Judge, this is Brian Driver for Seth Arterburn, and I like that idea because I think it gives us more flexibility because, we're looking at potentially going to the expense. I mean, from the plaintiff standpoint, I don't want to have to depose, 3 treating doctors if I don't have to, and, get into what my client is ultimately going to receive. So I like that idea, leaving
Right.
things kind of more flexible.
Right.
Your Honor, I would add Josh Ellis on behalf of DMB Trucks. This matter is set for trial in September. I don't know what your schedule is looking like. I know with the guidelines set down from the Supreme Court, that might be pushing back civil trials. And so if this disclosure deadline is moved back, which it looks like, I think we also need to discuss moving that trial date as well. Or we'll be operating pretty quickly in a short time frame.
Yeah, I mean, I think you're right that it is going to compress everyone's timeframes. Although I think that you probably, I mean, this is just one man's semi-informed opinion, but I think you probably could get, especially if you had your mediation at the front end of June and early part of June, you probably could still get your discovery and everything taken care of by the end of August or whenever it was that we were kind of shooting for. And what I was proposing, I guess, or suggesting is that why don't I just grant the motion to suspend those disclosure deadlines, and you all try your mediation, and then if you can't agree on where it goes from there, you come back as soon as you know that there's an impasse, and I'll try to address it. But in the meantime, I'd like to leave that date on if I can, just to see if you all can work towards getting everything done for it. But I understand if you can't,
Sure.
We'll just cross that bridge when we get there.
That's fair.
May it please the
Okay.
court.
Yes.
Judge, good morning. This is Travis Locke. This is the first time that I have appeared in this action, and I just wanted to chime in very quickly. I joined this action pursuant to the interpleader complaint that was filed by Flamingo Express, bringing in a couple of other parties. I represent Mihai Strungaroo, Full Speed Ahead, and TurboStar. Filed an answer to that interpleader complaint, as well as asserting their claims, my client's claims. It looks like I did that back in late January. So this is the first time that I've appeared. I just wanted to ask, Judge, it appears to me that trial date was set some time ago, certainly before all the parties were brought in. Is it, I'm going to show my ignorance here on what's going on with this case, but is that trial date you've got set, theoretically, does that include all the claims and all the claimants? Does that include me and my clients, or is that something the court has looked at?
Yeah, well, there hasn't been any mention, or I know you're just kind of getting into it at the tail end, which makes sense, given the procedural way that happened. But there hadn't at this point been any kind of mention of bifurcating anything or doing part of it here and part of it there. That doesn't mean that somebody wouldn't bring that up. But I mean, as of right now, since that hadn't come up and I haven't addressed that on my own, I've just been expecting that whenever we try it, if we have to try it, we'll try everything at the same time.
And I will say, Judge, that I've stayed in, although I've just recently entered this action, I have been involved in this particular case for quite some time, and I stay in good contact with Jared Portwood. But I would also say, Judge, in reviewing the e-filing, it's come to my attention. Some of the parties have not got me on their certificate of service. I'm not receiving all of the documents, although I am signed up for e-filing and I do receive the notices and I try to stay on top of all that. I would ask that that the other parties please include me in their certificate of service.
Yeah, I think that's certainly if you have filed a response and you're now counsel of record, you need to be on everybody's list. He on our list, didn't he? Yeah. We'll make sure you're on the court's list, but if you're getting electronic notices out of the case, then that probably means you're on it.
I am, Judge.
Okay. All right. So listen, for the time being, since what's on the table is extending or kind of temporarily suspending, I guess may be the way to put it, those disclosure deadlines, I will do that. And I think we can probably just whip up an order real quick at some point in the next day or two to put that in there, but that'll be what it says. And then it won't really specify anything else other than, you know, that you all will talk about maybe trying to come to an agreement on where we go disclosure wise after that. Okay. If it's necessary.
Yeah.
And then
Judge,
as we move towards that trial date, if there's other things that have to be brought up, you all know how to do it.
And I'll be happy to circulate once. I'm going to follow up with the mediator again today to make sure what dates are available in June. And when I do that, I'll also throw in there the point about, you know, how long do we want after we determine that mediation is or isn't successful to do the deadline. So, and we should be able to get that, you know, done in short order after that.
Yeah, I think so too. I agree. All right.
In your honor, we had several other motions on the table today, including motion for partial summary judgment to dismiss certain claims. Those were fully briefed. We have filed a reply pursuant to the order. And also there was a motion to amend filed by the plaintiffs in which they, in essence, sought to dismiss 6 of those consortium claims, to which D&B Truck filed a response. And then also we have filed a motion to compel defendant Flamingo Express and the estate of Richard Gray to serve responses to our discovery request, which are over 30 days due. They were served back in November and October of last year. I don't know if you wanted to address those now.
Yeah, sure. You know, I think the motion to compel is pretty easily addressed. I mean, my experience in those has generally been that, you know, the important thing to do is to have, when that gets brought to my attention, is to enter an order with a specific kind of drop dead date on it. And, you know, given that this is what we're in March and those were probably due in December from what you're telling me, you know, they're pretty, it's not unusual, but they're pretty substantially past due. And so I think that what you need is a specific date for me that those responses get submitted. I don't know if anybody wants to chime in on that.
I requested 10 days in the motion. I don't know. This was to Mr. Portwood's clients, and he had discussed in an email prior to this that he believes he can get some of those within the week. I don't know if you wanted to address some of those.
Okay.
Yeah, and I can. The holdup there, Your Honor, is unfortunately I've had little to no contact with our insureds. I have attempted to contact the representative of the estate of Gray, and unfortunately he is our only proxy to the claims against the estate. I don't believe there's anyone else involved in that. And when I call, write, email, whatever, I don't get a response. And so that has been part of the delay. And then also with Flamingo, he has been the manager, the dispatcher of that company, as the one who was deposed. And he has told me that he's going to provide me documents. I was just waiting to receive those to do a, full set of responses. But I think at this point, I'll just respond and say that those will be supplemented once we receive them. If they exist, I don't know. He hasn't advised of that, but I can get that done this week.
Well, I think it's important to get a like I said, a drop dead date. And then, I mean, everybody is, I mean, clients come in all shapes and sizes, just like everything else. And I mean, if they refuse to cooperate, they do so at their own peril. And especially once we've given them a specific date that says, that gives you something to send your person and say,
Right.
listen, the mean old judge is saying that none of this stuff's, that we're non-compliant or we're contempt of court or whatever you want to. I mean, I'm not going to micromanage your conversation with your client, but I mean, usually that gives you as much of a prod as you can hope for.
Yeah, absolutely. And that's fine, Your Honor. We'll
Yeah,
get him responses this week.
In your honor, I'll tender an order for 14 days. Does that work for you on the
That's-
granting
Yeah.
the motion?
That's fine with me personally. Yeah.
Sure. That works.
Okay. And with respect to discussing responses in which a client refused to produce them over top of an order, the estate of Johnson, you have entered an order for them to serve discovery responses. That was addressed in the motion to amend as well. The estate of Johnson, the consortium claims have not responded even after the time set in the order. The plaintiff filed a motion for an enlargement of time to respond to those. We have responded and also sought for legal fees and costs pursuant to CR 3704 and 02 for the failure to respond. However, those can also be addressed in the motion for summary judgment to dismiss them because they were filed over a year after the accident and pursuant to Floyd v. Gray. Those claims should be dismissed, Your Honor.
Yeah, and I think everybody has had the chance to file what they want to file. And I have not read everything that everybody has filed. So, I will need to do that before I make a decision on either your summary judgment motion or the motion to amend, right?
Okay.
So I mean, we can talk about it, but I haven't, like I said, we talked about it at the last hearing and then I gave everybody time to file some things. From what you're telling me, it seems like everybody has filed, we set it so that the time limits would be over with by the time we came back and everything's been filed. And I just haven't gotten in there and read it all.
Okay. Sounds good.
Your
Okay.
Honor. Yeah,
All
Your
right.
Honor, this is Andrew Norton on behalf of the estate of Johnson. I want to make a couple things clear based upon what Mr. Ellis just said. With regard to the estate, the actual estate of Johnson, there is no issue with overdue or outstanding discovery responses. That needs to be right off the bat very clear. Second, as it pertains to the individual claims that there was an order to produce the discovery responses before the time expired in that order, we timely sought an enlargement of time, and you'll see when you review it, Your Honor, as part of your reading that you have for everything that is sitting in front of you, you'll see that it was our position that either if the motion for summary judgment was to be granted or our motion for leave is granted, either way, it makes all of those discovery responses moot. And so there has been no willful disobedience. And I'm speaking to this on the point of seeking attorney's fees and costs against my clients and or counsel, which is pled by Mr. Ellis. And I just think that given the way that the time frame has played out and the motion that we filed, this is not something that the time expired on Your Honor's order, and we sought no relief. We did timely seek relief, and that is not a willful disobedience. It is simply trying to avoid additional time being spent on an issue that we have tried to resolve by way of our motion for leave to amend in response to the motion for summary judgment. With that, Your Honor, I don't have anything else to add. As you said, everything has been briefed and in front of the court for review.
Okay, fair enough.
If I could just respond to that, Your Honor, there is one claim that is not addressed in the motion to amend, or that does remain. I believe that is the child of Chloe James, I believe. So that would not fall under Mr. Norton's statement that either the dismiss applies or the motion to amend applies, because Ms. James, or the Chloe James, the child, has not served discovery responses. Those were requested, and those claims would remain if the court grants the motion to amend. So I just wanted to add that.
Okay. I understand. All right. Anybody else? All right, so I'll take that and look over all those other issues that we've got on the table. But we've certainly got the expert disclosure issue addressed. The other things came up, like I said, they came up what a month ago or whatever it was, and we've briefed them. So I'll get you a decision on those. Okay.
Thank you very much, Judge.
Thank you.
All right.
Thank
Thank
you,
you.
Your Honor.
Next case I have is 19 CI 426. That's Roarks versus Maston and Geico General Insurance Company, at least for now. Looks like what we have on that case is a motion pertaining to purportedly insufficient expert disclosures. Those expert disclosures were ordered pursuant to the trial order that was entered last year. Let me pull the file out here. This file is getting unwieldy.
Tyler Hall for defendant Brittany Maston.
It's right at the point. It's right at the point where the one file turns into two files, and right before that happens, it gets kind of hard to handle that one file. Looks like this, Mr. Musseter, is this yours?
Yes, Judge.
All right. I'm sorry if I mispronounced your name. Did I say it wrong?
No, you're a lot closer than a lot of people. That's pretty good.
Well, I try. Yeah, so I've got your motion. There is a response which was not, it actually I looked at this file this morning and the response wasn't in there. So that thing snuck in there in between 8 o'clock and 9 o'clock. So I haven't read the response.
Sure.
But you know, the issue I think is fairly, I think it's fairly, I don't want to say it's clear, because if it was clear, you all probably wouldn't be arguing about it, but I mean, it's fairly understandable, and from the sense that basically the plaintiffs are arguing that a disclosure that doesn't disclose any experts is not a sufficient disclosure. Is that basically what you're arguing?
Yes, Judge.
And I don't think it would be kind of hard just in a vacuum to disagree with that allegation. Since I haven't read the response, I guess, tell me what your response is to that before we even get to the question about what you would do about it if I agreed.
Sure, Judge. The disclosure was made within the time frame. The two experts were identified. One's a biomechanical engineer, one's a medical expert. Their areas that they were going to testify to were disclosed. No specific opinions were included because their final reports aren't done yet. I mean, we can't put specific opinions in the disclosure until they've reached a final opinion on the case. The way the two experts will work together is the biomechanical engineer will issue a report, and then the medical expert will use some of those opinions and then join those into his final report whenever it's ready. There were discussions with both experts. The medical expert starting in June of 2020, and he had records and multiple discussions with him about areas that he had testified to in preliminary opinions. And then there were discussions in January with the biomechanical engineer. So there were certainly discussions happening between counsel and the experts, but the experts haven't reached final opinions yet. And we've still got some time left in discovery. There are two potential witnesses that we've talked to our biomechanical engineer about, and that'd be the officer and the passenger in my client's vehicle. We're having some difficulty getting in touch with the passenger in my client's vehicle to determine whether or not we're going to need her deposition. So we didn't want him to issue a final report until we had all of those people who were involved in the actual accident. If he's giving opinions as to the severity of the impact and the forces and the delta V, then we need to have all of those individuals on the record and have their testimony for him to review. He could issue a preliminary report, sure, but that's subject to change in the event we take these depositions later in discovery. So That's why written reports haven't been produced yet. It's not that they're willfully being withheld. That's the reason why they haven't been produced. The case that plaintiff relies on simply says you can't willy-nilly blindly disclose an expert without having a conversation with them, without knowing what they're going to opine on, or at least have an idea of what their preliminary opinions are. There's a subsequent appellate court case that's cited in our response that clarifies that. The case that plaintiff relies on, the counsel just disclosed experts, but never had a conversation with them, never had any intentions of really using them until it was too late. And that's not the situation here.
Okay.
Judge, if I may reply,
Yeah, please do.
the case that he's referring to, Schneider Electric versus Williams, is an unpublished opinion that does go a little bit further into the issue. The bottom line is we all have to answer to somebody. I mean, obviously these experts have to answer to Mr. Hall, and they have deadlines, just like the court put deadlines before both parties. Our deadline was November 4th, which we complied with, and we have yet to see anything as it relates to the specifics, as Mr. Hall pointed out. Now, what he did go into as well in his response is that we can expect these reports by the close of discovery. It's going to be really difficult to move forward with these expert depositions if we're getting this report at the very end of discovery. What in effect is going to happen is we're just pushing this case further and further along. And, you know, it's been 3.5 years since the date of loss. The trial court had a very clear order that they put before us back in June of last year, which we've complied with, and opposing counsel hasn't.
The case I think is set for trial in August. I still think there's plenty of time to conduct discovery. Actually, the discovery is still open, but the expert depositions, if they want to take depositions of the experts, you'll have 3 months even between the final pretrial and the date of trial to do those depositions if you need to.
Well, I think the order says that the discovery is supposed to be completed prior to the pretrial conference. So that, and the pretrial conference is 2 months away. So I think that does truncate the timeline considerably from what you were thinking of. And listen, there's a couple of things here. First off, it seems like a whole lot of the cases when you get to digging into it, and I haven't done a lot of research on this, but this is not an issue that fails to come up. So, I mean, I've had other cases where this has come up, and it seems what's kind of harmful is that so many of the cases that are reported are medical malpractice cases, and there is, I don't want to say a different rule, but I mean, we all kind of know that if you've ever done any med mal cases, that there is, an expert requirement. And, when these cases, when these decisions come down, it's hard to extrapolate a rule that's going to apply to everything when it's talking about specifically about a medical malpractice case. You have to really get in there and parse it out and figure out what applies to all cases and what is kind of unique to medical malpractice cases from the standpoint of having an expert and having had an expert prior to filing the case and all of that. That's one thing. The other thing, in my view of what Rule 26.02 sub 4 requires, I do not think that these disclosures are adequate disclosures. I do think that that's part of the reason that if I enter an order in June, I try to give you until February. I mean, that's 8 months to have your experts form an opinion about. And when somebody's asking for a trial date, they've usually already mentioned at least to an expert or at least given them some information. And I mean, to me, even if those opinions might change slightly after some other expert testifies or whatever, the purpose of the expert disclosure and specifically the purpose of my order describing the time frame for expert disclosures and referencing 26.02 is that you guys need to be trading back information about what your experts are going to say, not just who they are. I mean, who they are doesn't make anywhere near as much difference as what they're going to say. So at least that's kind of how I see it. So, I think that the disclosure with no opinions or anything like that attached is not, strictly speaking, an adequate disclosure. However, the purpose of it is not to give people random rules and then penalize them for not complying with, the random rule that the court may have given them. The purpose is, as I mentioned, so that everybody has notice of what each other is going to say in time to complete discovery and decide who to depose and who not to depose and all of those other things that everybody has to do. So while I think that the disclosures are a little bit lacking, I don't think at this point, with the trial being 5 months away, that it would be excluding the experts would be the way to go, because I think that there is still time for those reports to or for those disclosures to be supplemented and for discovery to be conducted. There's not as much time as you all thought, because it needs to take place before the pretrial, which is in a couple of months, but there's still enough time for that to happen. So the idea of excluding an expert is that if it's unfairly prejudicial to the party that didn't get the disclosure that was sufficient under the rules. And I don't really think that it's prejudicial at this point, because there's still plenty of time for that to happen. Now, I say plenty of time because I'm not out here trying to schedule depositions, and I don't know what everybody's schedules are and that kind of thing. So it may not be plenty of time, but at least there's time. I mean, 60 days can depending on what you're going to do, can be a ton of time or not very much time. But I think at the very least, that's enough time for these to be supplemented, for these opinions to be submitted to the plaintiffs in compliance with the rule, and for you all to schedule your depositions. And if those opinions have to be fleshed out a little bit more between when they get disclosed and when the deposition occurs or whatever, that's not unheard of, and that's the kind of thing that happens. But I think a disclosure that doesn't have the experts' opinions in it is, it's kind of like those cases where they say, you can't file a complaint and then just to beat the statute of limitations and then add everything in later, ask to amend your complaint and add it in. I mean, because you haven't given anybody any notice of anything when you file it. And that's the point of filing the complaint. So, I think we're putting form over substance to just say, I'm going to identify somebody and say that I've talked to them about being an expert, and that complies with the rules about disclosure, when in fact, what they say is part of that rule, and if you're not going to be able to disclose what they say, then that isn't a sufficient disclosure. So I agree with the plaintiffs in the sense that these disclosures, I don't think, are compliant with Rule 2602, but I don't think that the appropriate thing to do at this point in time is to exclude those experts. I think the appropriate thing for me to do is to give you, Mr. Hull, a period of time to get the reports to the plaintiffs. And I think that should be done sooner rather than later. But I think that those experts have to be able to give their opinions. And if they can't, then they aren't disclosing much of anything that's useful. Does
Sure.
that make sense?
Yes, Your Honor.
All right.
And
So
Judge,
go ahead.
if I may, I just ask for a firm deadline as it comes to these disclosures. I think we kind of detailed in our pleading, we reached out back in February, hoping that it wouldn't come to this, that those initial disclosures would be supplemented, and we didn't get a response back. So this is kind of our hope that we can get this thing back on track, that you can provide a firm deadline for defense counsel as it relates to this disclosure.
Well, listen, I mean, you've got almost exactly, I would say it's probably 5 weeks until let me back up. That's not right. It's probably 2 months until the pretrial conference. So for there to be, and I believe the rule or the order says discovery to be done 2 weeks prior to the pretrial conference, because that's when the pretrial compliance statements are due. And so you have to know what to put in those. So, basically we're talking about less than 8 weeks away that all this needs to get done. And if that's has any chance of being done, then these reports have to be filed, sooner than that, and considerably sooner than that. And in my mind, probably by the end of this month would be the only way it would be realistic to think that you could get those depositions. I mean, that would give you a month to get the deposition scheduled. And, that if that doesn't happen, if those deadlines can't be met, whatever, then, we will have to cross that bridge when we get there by somebody bringing that to my attention and filing a motion and asking for either what you've asked for already or something else. And, but I'm not going to answer a question that isn't ripe to be answered. You see what I'm saying?
I understand, Judge. Yeah, absolutely.
So I believe that if we said March 31st, that's a weekday, so that's a good day. I think that to address your motion, I'm not going to exclude at this point in time any expert opinions, but I am going to direct that the expert disclosure be supplemented to bring it in compliance with the discovery rule, not later than 31 March by the end of the day. Okay.
Yes, Your Honor.
All right.
Thank you,
Any
Judge.
questions? All right. Thank you.
Thank you.
We'll do an order on that, so you don't have to send something in. Okay.
Thank you.
19 CI 772 JLB Advisors versus Unknown Heirs of Bunch et al.
My motion, Your Honor. We've had a warning order attorney appointed on this case for well over a year. No report's been filed.
Yeah, your motion is granted.
Thank you.
And I this has been a persistent problem, and I mean, just to put it on the record, I guess, but I gave Ms. Ryherd a show cause in another case, which she didn't comply with. And I told her if she didn't comply with it, that I was going to have her name removed from all warning order and guardian ad litem lists in Barron and Metcalfe counties. So that has been done. So we shouldn't run into this problem anymore.
Thank
I
you.
mean, I think I've had 4 of these in 2021, 4 hearings on the same issue already. And, we're 2 months and change into it. So, clearly that's a problem. It was a problem in family court too. So that's just how we addressed it. Okay.
Thank you.
All right. Did you tender an order? I mean, it's not like I can't do an order. Let me look.
I don't recall, Your Honor. I figured you would just use a new warning order attorney order.
Yeah.
I'll
take care
submit
of it.
whatever you want.
No, we'll take care of it. We will, I think I just have one from the last case I did, so I'll just change the names and go on. Okay? All right, Mr. Basil, I think you have another case, so I might just skip ahead and let you take that one. We don't have a lot left anyhow, but this is 20
I'm here on
CI.
several.
Huh?
I'm sorry. I said I'm here on several cases.
20 CI 637, Rogers versus Rogers, Franklin, and Franklin. Correct?
Yes.
Is it Mr. Richardson? Are you on that one too?
I am, sir. I'm
All
the
right.
plaintiff in that case, and I have a motion for default judgment against Mr. John Rogers and a motion for summary judgment against Donnie and Marlene Franklin. There hadn't been any response to either of those motions other than Mr. Basil's made a motion for a default on his cross claim against Mr. John Rogers.
All right.
To which I have no objection.
Yeah, I mean, it doesn't seem like that Mr. Basil's motion there is an issue because there hadn't been anything filed in response to your cross claim, right?
That's correct, Your Honor. And my client's apparently bought a piece of property without having the title run on it, and he's foreclosing on a judgment lien against the prior owner.
All right. So do you have any objection to the motion that Mr. Richardson has filed?
We do not, Your Honor. Go ahead and send it to the Master Commissioner, and if we have our judgment, we'll pursue Mr. Rogers individually.
All right. Well, I
This is
believe.
not the neighborhood, Mr. Rogers, now. This is not the neighborhood, Mr. Rogers.
I understand. No, that gentleman has been involved in another case recently that he just got a default judgment against him. So I think it was a car, like a failure to pay on a car. So anyway, I'm familiar with, well, I don't know who it is, but I know who it isn't. So that, you know,
I've
that's as
submitted a
close as I can get.
judgment. I've submitted a judgment and an order referring to the Master Commissioner.
Yes, sir.
I didn't send the $200, I don't think, but I will.
Okay. Well, you know how they are now. They'll hold it till they get that check.
Right, but I wanted to keep my money as long as I could.
I know. Drawing interest on that 200. Hey,
Right.
Mr. Basil, do you want to submit a default judgment for you? You may have, I don't know. I can't see my e-filing, so I don't know if you've done it or not.
I did not submit one, Your Honor. I wanted to make sure that I got a ruling on it for the hearing today. I don't know what the amount of the judgment would be until after the sale, though.
Okay, well, if you just want to get a judgment at, you know, in terms of the liability and then, you know, leave everything else for post-judgment.
I will do that, Your Honor.
Okay, all right,
Thank you.
thank you.
Thank you, Your Honor. I'll be legal.
All righty. Mr. Basil, you said you had several, is that? Nah, he gone. All right.
No, I'm still here. I
He's not gone.
don't have the file in front of me on the other one, so I
Well,
believe
let me
it was,
read them off and you tell me if you're on them, because
it
it
was
doesn't look
Kentucky
like
ad valorem versus Walker.
I don't have that one.
Okay, we tendered a non-objection reply, so it may have been taken off the docket. I just wanted to verify that it was.
Kentucky ad valorem versus Falk. Yeah, it is not on the docket, so it's probably
Okay.
taken care, but we'll check into it. Okay.
Thank you, Your Honor.
All right. Thank you. 20 CI 621, One Main versus Wheat and Wheat.
Yes, Your Honor. Jonathan Ryan for the plaintiff. And this is plaintiff's motion for default judgment.
Yes, sir. We've got personal service on both of these by our sheriff's department. One in, I think, November and one in December. I don't see any responses or other pleadings in the record. I don't see where anything has come back. I don't see any reason not to grant your motion unless you talk me out of it.
You don't have to worry about that.
Okay, all right. Looks, there's probably a electronically tendered order, so when I wrap up here, I can get on there and look, okay?
Correct.
All right,
Thank you.
thank you. Discover Bank versus Gentry.
Your Honor, Robert Dawson for Discover Bank. This was our motion for summary judgment. We'd like to pass on that today. We have reached a lump sum settlement due before the end of the month. If it clears and they pay, we will dismiss. If it does not, we will renotice our motion for summary judgment.
All right, fair enough. That'll work.
Thank you, Your Honor.
I'll just write that. Lakeview Loan Servicing versus Plum.
Good morning, Your Honor. Patricia Johnson for Lakeview Loan Servicing. It's our motion for default judgment.
How are you?
Wonderful. Thank you.
Let me get down in here and check. I apologize for not getting this checked before today.
That's okay. I totally
to-
understand.
Checking on the service, this looks like a person that Miss Klum, or Klum at least, is a person who has an ownership interest in some real estate here in Barron County, correct?
Yes, that's correct. And she lives in Warren County, and we had her served via Warren County Sheriff.
Okay.
We're good.
Yeah, it looks like she got served twice.
Yeah, it was a weird spelling of her name. And of course, it was like missing. It said like Angel instead of Angela. And I don't want to get into some, semantics there and trying to figure out, hey, did she really get served? So I made sure that she was reissued.
Gotcha. I can just give you one judgment though.
Yeah, thanks.
Okay. But yeah, I mean, sometimes belt and suspenders is the best approach.
I agree with you on that. I try to cover my bases, not what else I
Just
was
to
gonna say.
anticipate the objections and then, cut them off at the pass.
Yeah, exactly.
Yeah.
I'm like, I tell my client, they're like, are you sure? Nope, I'm going this way. So I do appreciate it. Thank you so much.
It's $50. That's cheap insurance.
Thank you. That's exactly right. I don't want to
Yeah.
hear somebody a year from now say, I don't think you got service. Oh, yeah.
$50 is pretty cheap insurance when you look at what everybody might have gotten into if you didn't do
Right.
it.
I have a question, Your Honor. I'm sorry. Is
Yes.
anybody else on the call?
No, ma'am, I think
I do have a question. Since you just brought that up with service, I guess we're not going to know where we're going to be. This has nothing to do with this case. Generally, what are we going to do with certified mail service down the road with these COVID signatures? Do you know that? I mean, I know.
no, I have had that come up one time,
Yeah.
that somebody filed a motion for default judgment. And I mean, and I didn't feel like I had a lot of choice. I just held that they hadn't been served and that
Yeah,
they could.
I've been going through and I'm just trying to do my daggondest at this point to make sure I get sheriff service. And if not, and if it comes back and it said COVID-19 or you can't tell what it is, I've been requesting warning order. And I just tell my client, I mean, you don't want to have a judgment unwound somewhere later,
Sure. I mean, yeah, certainly if you're doing some kind of in-rem,
Yeah.
a foreclosure type of in-rem deal, warning order is the best way to go because it's
Yep.
probably the most foolproof.
Right.
People are probably going to start doing special bailiff more if the sheriff can't serve, because
Yeah.
at least you get, they put a little bit more effort into it, which
Yeah.
is not to take anything away from the sheriff's department. But I mean, that guy's got 100, he leaves the sheriff's office every day with a big file with 100 summonses in it. And I mean, he's not going to chase people around.
Yeah, exactly. And
yeah.
I do. I just, how much are you appointing those in your counties? Special bailiff?
It really hadn't happened very often.
Okay, yeah,
I just think that it might be something that starts to happen more.
yeah.
I've done it several times in the last year. I do
Right.
not know that it has been more than previous years.
You
It's
just have
not
noticed
something that
it.
happens very often.
No,
Yeah.
no.
Yeah. I'd say maybe 5 or 6 times in the last year.
Okay,
in
that's
two
not bad.
counties.
I mean,
Yeah.
I'm licensed in Ohio and Indiana too, and we use those in Ohio quite a bit. I mean, we don't even use sheriff's service at this point in Ohio. But,
Right.
with respect to Kentucky, I've always just told everybody, I'm like, let the sheriff do it. We'll be fine until we probably get to one of these situations where if a sheriff's office isn't going to do it, but whatever. But I do appreciate it.
It depends on the judge because
Yeah.
I mean, I usually require that you comply with the statute to get
Yes.
a special bailiff, which is not just you can get one just by asking. It's that you can
No.
get one if you show any of those